then let's stipulate to the facts. And let's put them before the jury and agreed on stipulation and not put the integrity of this witness at issue. That's his ethical obligation to propose that.
All right. Thank you, counsel. Ms. Lewis, are you handling this?
Yes, I am. Thank
All
you.
right. Good afternoon.
Your Honor. Your Honor, first I want to make clear that we're not seeking to disqualify Mr. Kardashian from representing the defendant as one of his several defense attorneys in this case. I think his participation in the case as a defense attorney, however, is different and distinguishable from the participation of all of the trial attorneys. There are, I've counted, 8 trial attorneys on the defense team who have acted as advocates in front of the jury in presenting evidence to the jury, at least one of whom will be arguing to the jury during closing argument. So we don't have a normal situation here where the attorney, the one trial attorney on a case, would be testifying and then put in a position of arguing his own credibility in front of the jury. It's a distinguishable situation. Meredith is clear, Your Honor, that the prosecution is entitled to the information that we're seeking, and we're entitled to it because Mr. Kardashian chose on the 13th of June last year to remove a full Louis Vuitton suitcase from the defendant's premises. Now, this footnote 8, which counsel refers to, does not really apply in this situation. In the Meredith case, the concern expressed by the California Supreme Court in that footnote was that it not appear to the jury or to the fact finder that, Your Honor, there is a great deal of discussion going on over here. If you could ask the...
Keep it down to a dull roar. All right. Thank you. Proceed.
Thank you. The concern in the Meredith case was, the situation in Meredith was that the defendant in that case told his lawyer, or told the investigator that he had evidence in some unknown location, and so the investigator went and got it from the location and then testified in front of the jury at trial. Implicit in that testimony, even though he was of course not asked that, was that the information as to where it came from, because it was very incriminating to the defendant, implicit in that is that the information as to where it came from must have come from the defendant. So the concern expressed in that footnote is that there not be a necessary inference that the information as to the whereabouts of the evidence, because it's incriminating, came from the defendant, so as to protect his attorney-client privilege communication to the investigator. We don't have that situation here. All of the evidence is already in the record as far as the relevance and the foundation for the bags that are an issue here, particularly the Louis Vuitton bag. The limousine driver testified that that was the type of bag that was taken to the airport. The skycap testified that Mr. Simpson checked that into the airport. There's been evidence now that it indeed came back from Chicago because of the airline, the luggage tickets, which still remain on it. So there's all of the foundation, and we do now have a videotape of showing Mr. Kardashian leaving the defendant's premises with this same full Louis Vuitton garment bag.
When you say, Ms. Lewis, that you now have, how do you define now? When did this information become apparent to the people, and when did the materiality or potential materiality of Mr. Kardashian's testimony become apparent to the people?
As far as when we became aware that he took the tape, it's really difficult to say. We have seen, I don't know, and I don't think any of us can say for sure when we first saw the videotape. But when it became material was dependent on 2 things. First, on the fact that it became empty at some point in time, and second, and most importantly, on when the defense chose to put that bag before the jury. We had no intention of calling Mr. Kardashian as a witness or of introducing that bag prior, and we still had no intention of introducing that bag, but certainly no intention of questioning with regard to it until the defense in chambers brought forth the issue of these bags and elected, at that time, made a tactical decision to put that bag as well as the others in front of the jury. And when they did that, if that was something that they had been planning to do all along, they had an obligation. We're back to the discovery stage.